Hello, I'm Barry Lerner. Under the Longshore and Harbor Workers' Compensation Act and the Defense Base Act extension, medical benefits are delineated under Chapter 7. More specifically, an injured employee whose claim is accepted as compensable is entitled to have all reasonable medical care paid by the carrier. Well, that is all well and good as what it says. In reality, in handling claims on behalf of injured workers, we see problems all the time. First of all, if the claim is not accepted as compensable or denied by the carrier or under investigation, the carrier is under no obligation to provide benefits. That in and of itself could prompt hours and hours of discussion. But turning to the more specific of when a claim is compensable, under the Act, the employer carrier is responsible for all payment of bills, and the client or the claimant should not have to pay anything out of pocket. Again, that's what the statute says, but in reality, doctors' offices and hospitals will very often and quite commonly ask for the employee's group health insurance or ask the claimant to sign releases or obligations in which they would be responsible for any payments not made by the carrier. This should not be done, and the law is very specific that in a compensable claim, the provider must accept the fee paid by the carrier and cannot look and should not look to the claimant for any payments. Again, the difficulty is reality and practice. Very often we encounter clients who are told they have to pay up front or the facility requires a co-payment. Again, we can get that back through requesting reimbursement from the carrier, but things should be taken care of up front. The carrier should acknowledge the obligation, and the facility also should know that the carrier is to be billed 100%. Additionally, under the Act, if your treating doctor believes additional care is needed, whether that be diagnostic studies such as EMGs, X-rays, MRIs, or referrals to another specialist such as a neurosurgeon or neurologist, the employer carrier's workers' compensation carrier is responsible for that future care. Again, it has to be coordinated through the carrier, but if the carrier either delays or denies, then that should be brought to the attention of the Department of Labor immediately. Obviously, a claimant who is represented by counsel, such as our firm, is made aware of their rights, and we notify the appropriate individual, whether that be the adjuster or the Department of Labor, if there are any delays in authorized medical care. Another difficulty we often see is where a client of ours goes on his own to seek medical care without either notifying the attorney or the adjuster. At that point, the adjuster can deny the care as saying it's unreasonable, but again, the determination is made after the fact, either through the Department of Labor or through the administrative law judge. Again, I have just touched the surface of medical benefits in an authorized claim, and if you have any other questions or concerns, please feel free to contact us at www.barnettandlerner.com. Thank you.